May it please the court, my name is Tyler Cavanis, representing the appellant Timothy Dewayne Pinion, and I'd like to reserve 3 minutes for rebuttal, please.
Thank you.
Your Honors, Mr. Pinion, this is a case where, just to briefly go through the facts relevant to what I'm arguing here on appeal, this is a situation where Mr. Pinion was convicted of vehicular homicide and reckless endangerment, among other things, but he was driving in a rural part of Knox County and was convicted of crossing the double yellow line on a 2-lane road in an apparent attempt to pass a number of vehicles somewhere, perhaps 1 to 3 vehicles, and when he did cross that double yellow line, there was a motorcyclist in the oncoming lane who Mr. Pinion collided with head-on, and ultimately the motorcyclist was killed. And so the issue on appeals, Your Honor, or on appeal, Your Honors, is that I believe the trial court erred by imposing consecutive sentences in this case for the vehicular homicide count and the reckless endangerment counts. There was a 10-year sentence imposed for the vehicular homicide, which was vehicular homicide by recklessness, was what he was ultimately convicted of, and then a 4-year count or 4-year sentence in the count charging reckless endangerment. And so significantly, for the reckless endangerment count, the same victim in the vehicular homicide count was the named victim in the reckless endangerment count. So the indictment alleged that Mr. Pinion killed the decedent recklessly with his vehicle in the vehicular homicide count, but then also that he recklessly endangered the decedent with a deadly weapon in the reckless endangerment count. And the indictment did say that the victim and others unknown to the grand jury. So there were other unknown people referenced in the indictment, but no other named victims, and also no other reckless endangerment counts with a specific named victim. Although the proof at trial was that there were other people on the road, the indictment did not specify or reference any specific person. And so, Your Honors, I think where the first dispute of this case comes in is that when we're looking at the Watkins test and ultimately the Blockberger analysis to determine whether this is a double jeopardy issue, the first threshold for the court, or first threshold question for the court, is we know that the legislature, or at least we on appeal the parties agree, the legislature has not established a clear intent one way or another to permit multiple punishments for both vehicular homicide and reckless endangerment. And so the first threshold question for the court then becomes, did this event arise out of the same act or transaction? Because, of course, if it was not the same act or transaction, there would be no double jeopardy issue, and the court's inquiry ends there. And so that's where I believe we have the first disagreement between the state and the defense in this case is, was this the same act or transaction? And so, of course, on appeal, we're arguing that it was. This was a situation where the indictment charges, of course, the same person, Vincino Sinelli is the decedent in this case. He was the victim of both the vehicular homicide, also the reckless endangerment. And factually, we're talking about an event that occurred just moments apart. Mr. Pinion attempts to cross these vehicles by crossing the yellow line, and in that same act, it appeared he wasn't even successful in getting around the vehicles he was trying to pass. He hits this motorcyclist. And so the state argues on appeal that because there were multiple victims in the roadway, Tabitha Walker was one, and there was another vehicle behind where Mr. Pinion was, that these people were also recklessly endangered, and because there's multiple victims involved, this isn't the same act or transaction, therefore the court's analysis ends there. And so, Your Honors, I think we do have an answer to that question, at least. We have some strong help, I would argue, from the Tennessee Supreme Court in answering that initial threshold inquiry. The state cited State versus Cross, which is a 2012 opinion from the Tennessee Supreme Court. And in that case, the defendant was charged with both felony evading arrest, or he was ultimately convicted of felony evading arrest as a lesser included, and also felony reckless endangerment. The reckless endangerment count in that case did not allege a specific victim. It essentially alleged that the public at large was the victim of the reckless endangerment action. And so when the Tennessee Supreme Court was looking at are there multiple victims alleged here? Is this the same act or transaction? Do we go further in our Blockberger analysis? The court specifically relied on the fact that there was a named victim in the evading arrest count. There was the law enforcement officer. It was a felony evading arrest. So there was a law enforcement officer who was the named victim in that count. And then by charging the reckless endangerment count as against the public at large, the court treated that the same as if the state had not named a victim. And so they said that this is not a case where there are multiple victims alleged to have been acted upon or endangered. There's just one victim here. This is all one act, and therefore this is a potential double jeopardy issue. We do get past this threshold question. And so I think that Cross is both instructive, but ultimately I would argue it's determinative of, do we even get past this threshold question of, is this the same act or transaction? Is there a potential double jeopardy issue? Here, there's only one specific victim named in the indictment. It is the decedent. The argument that, or the information in the indictment that there are others unknown to the grand jury, that is essentially the equivalent of, I would say, saying the public at large. There's no specific person named. I think the analysis in Cross is ultimately controlling here, that there is just one named victim in this indictment. There is just one specific act or series of acts that we're talking about. We do get past this threshold question and then need to move on to the Blockberger-Burns analysis of, are there separate elements between these two statutes, or does essentially the harm, if there is a difference in elements, does the harm of one statute, is it entirely subsumed by the harm that the other statute targets?
Mr. Cavins, let me ask you a question. Okay. Did you raise any of this in the motion for new trial?
Yes, Your Honor, and I'm of course aware that the state is arguing that this should be reviewed for plain error on appeal. The motion for new trial specifically took issue with, or specifically listed as an error that the court imposed consecutive sentencing here. And so in my reply brief, I've cited a number of opinions where the Tennessee Supreme Court and this court, or the Tennessee Supreme Court instructs that in reviewing a motion for new trial, it should be reviewed, I don't know that they use this word, but I would say graciously perhaps, in the sense that the defendant is not expected to fully brief an issue, but just needs to fairly raise the issue so that it can be addressed by the trial court, and so that the state would be aware of what argument needs to be responded to. And so the remedy for a double jeopardy issue would be merger of the convictions, and so by raising the error related to the consecutive sentencing, I think that does fairly include this double jeopardy issue, because if there is a double jeopardy issue, then the trial court did err in imposing consecutive sentencing.
Did you use the word constitutional or double jeopardy or anything in the proceedings below?
No, Your Honor. I was not trial counsel. Well, actually, that's not true. I was counsel at the motion for new trial hearing, although trial counsel had filed the motion for new trial that we ultimately relied on. But, Your Honor, I would rely on the case that I cited in my reply brief, which is State versus Howard. And in State versus Howard, the defendant had asserted, as the court described, and that was a case out of this court from 2013, the defendant had raised what this court had described as a general claim in his motion for new trial that, quote, the trial court erred by not replacing a juror with an alternate juror. And end quote. That was as I understood that case, that was the extent of how the defendant appellant had raised that issue in his motion for new trial. But then ultimately on appeal, the appellant argued more specifically that there was a constitutional error for failing to replace that juror because it affected his right to a trial by jury and his right to exercise preemptory challenges. And so,
would you agree with me that, I mean, from that case, It's pretty clear what the implication is, that there's a right to a fair and impartial jury, but here there's different reasons that sentences can be imposed consecutively. I mean, there's the statutory element or side of it, and then there's the constitutional side of it. And would it not be a stretch to get from the language in the motion to new trial that this is a constitutional challenge under Blockberger and double jeopardy?
Well, of course, I don't think so, Your Honor. But of course, I understand the court's question, and I think that's where the Tennessee Supreme Court's instructions to the lower courts that a motion for new trial should be, while it must fairly raise the issues, it should be viewed, I guess, in favor.
Graciously, I'll say liberally, but
Yes, Your Honor. I think that's ultimately, I think that's the umbrella that we would be trying to get under, or that's the opening that we would be relying on. Because of course, Your Honor, I mean, I do recognize there are multiple reasons, but I suppose on appeal, the state has had every opportunity. I mean, this is an issue that was fully briefed on appeal. The state has had the opportunity to respond to that. And I suppose I would argue that the state was not prejudiced by, of course, it wasn't specifically argued at the motion for new trial, but the parties have had an opportunity to fully address this now. I would say that this hasn't put either party in a negative position, and ultimately this is essentially the only issue that Mr. Pinion has raised. This would work severely to his detriment. So in a situation where there is instruction to liberally view these motions for new trial, this is a situation where the state has fully had an opportunity to address the issue, and ultimately this would foreclose Mr. Pinion's direct appeal if this issue is deemed to be waived. I would say that all weighs in favor of this court giving de novo review to this issue.
that's true, but a motion for new trial also gives the trial court a chance to rule on these issues, right?
I recognize that, Your Honor. And so the other issue where I think that the parties have a significant disagreement on appeal is once we get through this threshold issue of was this out of the same act, or other than whether this was a plain error or whether this was waived, once we get past this threshold question, there then becomes the issue of under Burns, looking to whether this was a lesser included offense. The court must examine the statutory elements of vehicular homicide and compare those to reckless endangerment. And so I think as the backdrop of this analysis, the issue in Mr. Pinion's case fundamentally is there's really never going to be a situation where you are going to kill someone with your vehicle that you're not also recklessly endangering that same person. I recognize that had there been a reckless endangerment count that alleged a different victim, or I think probably if there had been a reckless endangerment count that separately alleged danger to the public at large, separate from the decedent, probably there's no issue here. There's certainly, it's clear, and there's case law supporting that that danger can be prosecuted separately from what the ultimate conclusion of that dangerous act may be. But here the problem is the state prosecuted Mr. Pinion in the indictment under a theory that he both killed the victim and also that he recklessly endangered the victim. And ultimately, because of the consecutive sentences in this case, he was punished twice for the same ultimate object of that act. And so
let me just ask you, so you're saying that even though it makes, the reckless endangerment indictment makes reference to other unnamed individuals, because you're saying that it mentions the deceased victim, that you just ignore the rest of it and the only thing you focus on is the deceased victim? Because you're saying because the deceased victim's name is in there but was included with unnamed individuals, you're basically excluding unnamed individuals.
Well, and
for double jeopardy, for double jeopardy.
And I don't mean this at all to be cute, Your Honor. I guess the flip side of that would be to say that because the flip side of that argument would be to say that because they included other unnamed individuals, that means we should then ignore that the specific named decedent was listed in the indictment. And so, Your Honor, I think that ultimately what we get at is we don't know what the jury relied on to return a verdict in that count. We don't know whether they believed that that Mr. Pinion endangered the victim, these other unknown people, or some combination of both of them, or all of them. And so I think that
Did the jury instructions for reckless endangerment mention the deceased?
I don't recall, Your Honor. I can.
I just wondered if
I don't recall.
the judge may have instructed. Okay.
Didn't a female driver, I don't remember exactly, testify that she was like beside the defendant when he hit the motorcycle, and she had a child in the car, and I can't remember all of her testimony, but something to that effect?
Yes, Your Honor.
And so she was in close proximity to where the collision occurred.
And I think that for this analysis, it does call, the court is called upon to look at the statutory elements of the offense. And so I'm not sure that when we're looking at the indictment as it's charged, I'm not sure that how the proof actually came out at trial matters in determining, in answering this question. And so in looking at are the elements of reckless endangerment fully subsumed within the elements of vehicular homicide, I recognize the state has cited cases not dealing specifically with reckless homicide, or vehicular homicide, but dealing with other vehicular assault type cases. And I recognize there is a statutory difference between vehicular homicide, saying the word vehicle specifically, and reckless endangerment using the word deadly weapon. But I think that in this case, it really is a semantic difference. I realize we're lawyers, semantics matter, but when you're talking about killing someone with a vehicular homicide case, that is always going to be used as a deadly weapon. And so it necessarily requires the use of a deadly weapon for both offenses. And, Your Honors, I will conclude my argument on rebuttal.
All right, thank you, Mr. Gavis. All right, General Redding.
May it please the court, Catherine Redding on behalf of the state. The defendant has waived his claim that his convictions for vehicular homicide by recklessness and reckless endangerment with a deadly weapon violate double jeopardy. The Tennessee Supreme Court has stated that in order to preserve this issue for appellate review, the defendant must raise the issue in his motion for new trial. Here, the defendant made no mention of a double jeopardy claim in his motion for new trial or at the hearing on his motion. He presented a five-item list of issues in his motion for new trial, claiming as relevant that, quote, the trial court erred by ordering consecutive sentences in counts 2, 3, and 9, which would be the vehicular homicide, the reckless endangerment, and a DUI conviction that has not been challenged on appeal. The bare assertion that the court erred by ordering consecutive sentences did not preserve a double jeopardy claim, and the defendant offered no other statement about this issue such that it could be understood as a double jeopardy claim in his motion for new trial. And then at the hearing on his motion for new trial, he said that he would just rest on the motion. There are no statements in the record by the trial court or by the state that indicate that anybody knew that this was a double jeopardy claim. The defendant is correct in his reply brief when he says that motions for new trial need not be briefs and that appellate courts should not lightly dismiss issues under a strict or technical application of the rules that apply to motions for new trial. But the state is not asking for a strict or technical application of the rules. It's asking this court to fairly apply the existing rules and find that the defendant failed to meet his burden of preserving this issue in a motion for new trial. The defendant's motion did not allow the trial court to consider the issue and make an appropriate ruling. It doesn't really matter that the issue is fully briefed in the appellate court and that the state is able to respond. What matters is that the trial court didn't understand that this is an issue because it wasn't in the motion for new trial and it had no opportunity to consider the issue and rule on the issue. The defendant did not set forth the legal grounds for the trial court's ruling. Obviously, he's made a claim that the trial court erred by imposing consecutive sentences, but he hasn't explained why the trial court's decision was an error. The defendant also failed to direct the attention of the trial court and the prevailing party, in here, this case, the state, to the asserted error. He hasn't specified the issues with sufficient certainty to allow this court to determine whether the issue was first raised in the trial court. And that is the problem. The motion for new trial simply doesn't do what the defendant's motion for new trial doesn't do what it was required to do. It's not sufficient to preserve a double jeopardy claim. As to the cases the defendant has relied upon in his reply brief, he is not entitled to relief under either one of those, mainly Howard and South. South, as an initial point, really doesn't offer this court any information on how it should treat the defendant's motion for new trial. And South, it said the defendant's motion for new trial was sufficient to preserve the issue, but there's no discussion of what's actually included in the motion for new trial. So really all it stands for is this proposition that a motion for new trial can, under certain circumstances, be sufficient to raise an issue, even if it doesn't offer specificity as to the particulars of the claim. But Howard is distinguishable from this case. The Howard court found that the defendant's general claim that the trial court erred by failing to replace a juror with an alternate was sufficient to preserve a claim that the reason for this error was because the failure to replace constituted a structural error that affected the right to a fair trial and a jury trial and the right to use peremptory challenges. But Judge Wilson, as you pointed out, there is a clear path from the defendant's motion for new trial in Howard to the issue he raises on appeal. Imagine you're going down a hallway, there's really only one door. But here, the defendant's motion for new trial, by saying simply the trial court erred by imposing consecutive sentencing, with the addition of a third count that isn't discussed now in a double jeopardy issue, kind of is more like a hallway with 3 doors at the end. Yes, it could be a double jeopardy claim, but it very easily could have been a claim that the trial court didn't make the required findings to impose consecutive sentencing, or that there were no statutory factors that apply to impose consecutive sentencing. And so for that reason, it's the state's position that Howard really doesn't offer the defendant the relief that he claims it is offering him, because his motion for new trial, the vagueness and the lack of explanation is very different than Howard's, in that in Howard you ended up in one place. Here there's a variety of places you could end up. And it's the defendant's burden of raising a double jeopardy issue in his motion for new trial. And when he points out in his reply brief that the trial court and the state were aware that there was an issue related to consecutive sentencing, that is not enough. It's the defendant's burden. By pointing this out, he's suggesting that the trial court and the state had a duty to interpret the defendant's claims and for something other than what they were. It's the defendant's burden to preserve an issue in a motion for new trial. The defendant has not met that burden. And the issue is not, well, he hasn't met the burden. It's not necessarily he hasn't raised this issue in his motion for a new trial, and so the issue is waived and this appeal should be dismissed because the issue is waived, but rather the defendant had an opportunity to request plain error review, but he's not request plain error review. He has an alternative. He's not request plain error review. He hasn't talked about any of the plain error factors. This court's authority to review unpreserved issues for plain error is discretionary, and this court has had several opinions of late that have said that. And the Tennessee Supreme Court, has said that this court the authority to exercise plain error review should be used sparingly. Even now, the defendant has not offered any argument about the plain error factors, has insisted that plenary review is the appropriate standard, but it's the defendant's burden to show that he's entitled to plain error review. And when he hasn't requested that review or established he's entitled to that relief, that necessarily weighs against any consideration of the plain error factors by this court. It's the state's position that this court should decline to engage in plain error review and should deny relief. But even if this court were to disregard all of that and decide to engage in a plain error review, the defendant would not be entitled to relief because, first, he can't show a breach of a clear and unequivocal rule of law. The parties, I think, are in agreement that the General Assembly didn't provide any guidance in the statutes as to whether multiple punishments for vehicular homicide by recklessness or reckless endangerment with a deadly weapon, whether multiple punishments are prohibited or precluded. So then we go to the statutes, we go to the next question is whether the statutory violations in this particular case arose from the same act or transaction. And I point out that the testimony obviously is all on the record and this court can read it for itself, but the state's reading of the proof is that the defendant passed one or two cars, according to Ms. Walker, did so successfully, and then attempted to pass Ms. Walker. And that it is the reckless endangerment occurred when he, at a very high rate of speed, attempted to pass the first two cars and then Ms. Walker. But then after he successfully passed them, he tried to pass Ms. Walker, and that is when he hit Mr. Sinelli by being partially in oncoming traffic, the lane of oncoming traffic, and partially, it seems like he was straddling the center line. And at that point, he's straddling the center line next to him, very close to Ms. Walker. That is when he struck and killed Mr. Sinelli, and that is the vehicular homicide. And additionally, the indictment does list Mr. Sinelli only as the victim for the vehicular homicide, and then says Mr. Sinelli and others in the indictment for the reckless endangerment with a deadly weapon. And I don't believe that the jury instructions named the victims for either count. But my recollection is that in closing arguments, the state did, as to the other victims portion of the reckless endangerment, did specifically identify Ms. Walker and the minor in her vehicle as also being victims of that particular offense. But even if this court were to find that the acts, that the convictions did arise from the same act or transaction, that's not the end of the analysis. The defendant still would not be entitled to result because the elements of the offenses are not the same, nor is one offense a lesser included of the other, either by statute or under Burns B. Vehicular homicide, and this is all set out in my brief with cases that have discussed this, but vehicular homicide by recklessness requires proof of a killing, but reckless endangerment, with a deadly weapon does not. Second, vehicular homicide by recklessness requires the use of a vehicle, but reckless endangerment with a deadly weapon does not require the use of a vehicle. It just can be committed with a vehicle. And finally, reckless endangerment requires proof that the offense was committed with a deadly weapon, but vehicular homicide by recklessness does not require a deadly weapon by statute. As a result, dual convictions for this reckless endangerment and the vehicular homicide do not violate double jeopardy. Because the defendant has not shown the breach of a clear and unequivocal rule of law, he also can't show that a substantial right has been adversely affected or that consideration of the alleged error is necessary to do justice, substantial justice. Because no plain error exists, the defendant is not entitled to relief. Unless this court has any questions, the state would ask you to affirm the judgment of the trial court.
Thank you, General.
Thank you.
All right, Mr. Cavins, your rebuttal.
Judge Montgomery, to address your question about the jury instructions, the state is correct. It's Exhibit 77 of the exhibits. It says a person related to reckless endangerment, not a specific person. I'd like to spend my remaining time talking about what is referred to as Part B of the Burns test, Burns recognizes that either it's a lesser included offense either when the elements are entirely subsumed within another, or if there is a distinction between the elements, if the second charge establishes a less serious harm or risk of harm to the same person, property, or public interest, it may still be a lesser included offense. And I note, or I'll reference State versus Steelman, which the state cited in its brief. That was a vehicular assault case and a reckless endangerment case, and that was an opinion authored by Judge Montgomery, where this court was reviewing under plain error whether there was a double jeopardy issue there, and held that it was not, given the distinction between requiring a vehicle versus a deadly weapon. And I would note in that case that because it was reviewed under plain error, there really was not a particular analysis of the issue as I've raised it in Mr. Pinion's case, where inherently when you have the same victim, which I don't believe it was the same victim alleged in those two counts in that case, when you have the same victim being the victim of a homicide, a vehicular homicide and a reckless endangerment, there's necessarily the vehicle is always going to be a deadly weapon in the vehicular homicide count. But then also that case didn't have this secondary Part B Burns analysis of whether the reckless endangerment just referenced a lesser harm. And so I think as an alternative argument in this case, to the extent that there is a statutory distinction between the elements of vehicular homicide and reckless endangerment here, as it's charged, which is naming the decedent in both counts, reckless endangerment is just establishing a lesser harm of the killing. If you are recklessly endangering someone, or if you have killed someone with your vehicle, it necessarily they were in danger for at least a moment, if not several moments, prior to the killing taking place. I just can't really imagine a scenario where that doesn't occur. And so I think specifically to this set of circumstances and the indictment as it's written in this case, where the named victim is the decedent in both of these counts, this is a lesser included offense, particularly under Part B of Burns, because if there is an elemental distinction, it does just establish a less serious harm to the decedent. Thank you, Your Honors.
Thank you, Mr. Garrett. Thank you, counsel. We'll take this under advisement, get you an opinion out shortly.
Have a good day.
We're going to take a short break, and we'll be back in just a moment.